Sébastien Treyer. I'm the director of IDRI, the Institute for Sustainable Development and International Relations. And IDRI is extremely pleased to host this very important webinar. And I really want to thank our Associate Research Fellow, Marta Torres-Schaub, for having proposed and organized this meeting with the eminent scientists who are around the table, eminent experts around the table. So thank you very much, Marta, for that. And I will present the three of you in a minute. I just want to say first that you probably know that IDRI feels a bit that we have a role of being one of the warrants of the Paris Agreement, because we have this affiliation with Laurence Tubiana and the COP21 effort that she made. And this means that we are always very interested in innovations in governance and how they restructure the playing field for global commitments on climate to really become a reality. And I think the bet of the Paris Agreement was that beyond, or instead of a proper compliance mechanism at UN scale that would have been completely impossible to negotiate, there are lots of legal effects, a variety of legal effects that the Paris Agreement could be having and would be having across scales, linking local and national action to trigger transformation with the national and global commitments, sometimes enabling commitments at international scale because action is taken locally, but also pushing national scale or local scale action because you have these commitments globally. And it is in that regard that the litigation cases that we see emerging are for us extremely interesting because they show a variety of linkages across scales with national and global long-term commitments, and also across private and public boundaries. So I think there are lots of very interesting issues there. And not only, as I was saying before, not only in a bottom-up approach, but also bottom-up and top-down. So I think this is an extremely interesting part of why we believe that the Paris Agreement has effects and is working. But I believe that's not exactly the only angle through which you could listen to this webinar. I was, by this short introduction, insisting on the fact that there is an issue of effectiveness of international governance. How are those international commitments really playing a role at other scales to really impact reality? And I think this is also very important in the current moment where we see a lack of credibility of many of the environmental commitments that are taken by many actors, businesses, local governments, saying climate neutrality is our goal, but very long term. So how is that related to what we do today, and how can we make that much more credible? I'm not saying that these commitments are not sincere, but they are so far away that it's quite complicated to see how they can translate. And of course, the discussion of today is also an issue of international justice. I would say that at IDRI, one of the reasons why we supported the Paris Agreement that is quite imperfect in the way that it gives voices to everybody around the planet. I mean, the rights-based approach is not very important, for instance, in the Paris Agreement. But the first criteria of justice in the Paris Agreement is that if you want to be just on the climate crisis, you need to be efficient. If we are able to maintain climate change under a certain level of degree, then this is going to be important for justice. And that might be quite instrumental. And I know in front of whom I'm speaking and saying that, but I think this is why we really mix at IDRI the understanding between effectiveness and justice of these issues of global commitments. I would not say more. I would just present our three speakers this afternoon. So Marta Torres-Schaub, Marta, thank you very much again for pushing forward this idea of a webinar and inviting very eminent colleagues. Marta is a research director at CNRS in France, specialist in environmental law and climate change. And as I said, we have the honor that you're also a associate research fellow at IDRI. Professor Michael Garrett, thank you very much, Michael. Professor at Columbia University School of Law and founder director of the Sabin Center for Climate Change Law. So really one of the most eminent specialists of this issue. And Felix Eckhardt, lawyer who initiated the Göppel et al. Case in Germany, the very well-known, you might know it as the Neubauer case. I don't know if that's if I'm mistaken, but that might be another way that you might identify it. And you're director of the research unit Sustainability and Climate Policy in Leipzig, and professor of public law and legal philosophy at the University of Rostock. So you see, we have I mean, don't know if Martha, you would be presented only as French, but Paris-based specialists, the US, Germany, a lot of interesting panorama of all that's happening. Local cases, as I said, being very important for global governance. And that's really at the heart of what we want to discuss this afternoon. So Martha, you will give a first general introduction, and then we will hear Michael and then Felix. The floor is yours, Martha.
Thank you. Thank you very much, Sébastien. Good afternoon, and thank you to the IDRI for organizing that, and the staff, and also, of course, Karine, Pierre, and very welcome to our hosts, Professor Michael Gerard and Felix Eckhart. I will present very briefly a panoramic view on climate change litigation to show some trends and perspectives. As we know, the number of climate litigation cases has considerably grown those past years. Especially this year was very fruitful. The climate change litigation of the world data set includes more than 900 court cases across 60 jurisdictions. Since the middle of 2000 and after the Urgenda case, very well known in 2015, the first audience, there had been at least 10 new court cases a year. Tribunals and courts are increasingly exposed to climate change arguments in cases, and until recently, as the last report of the Ransom Institute underlines, the environmental argument would not have been framed in the same terms as it is today, including climate change, very strong arguments. Indeed, the last decade, climate change has been used as part of the argument of those innovative cases, and it's even a core factor of all those cases of what we call today the strategic climate litigation. This strategic climate litigation generally involves the use of the law and court action to advance beneficial outcomes for addressing climate change. The predominating model for this strategic climate litigation has been to challenge governments' decision-making under planning and environmental legislation. But now, strategic litigation goes further in terms of time with long-term decisions, including future generations, we will see. Also in terms of actors, because we are including the private sector, we are including towns, cities, and last but not least, in terms of which kind of court is being mobilized, because even constitutional courts, civil courts, and human rights courts are now involved in climate change strategic litigation. We can see that there are different avenues in this litigation, including human rights, fundamental rights litigation, and also financial, corporate law, and civil law. Climate strategic litigation has a double purpose. On the one hand, it can be used to facilitate climate regulation, as I said, by driving, enforcing, and clarifying climate policies and legislation. In the other hand, it can be used to enhance, reinforce climate responsibilities, asking for more transparency, climate disclosures for private actors, and even to strengthen their liability against both stakeholders and even consumers. Those last years, the incrementation of this strategic litigation shows a third purpose, which is what Sebastian underlined, making international law, the Paris Agreement, more effective. We can so observe what some authors consider a shift in climate change litigation, or it can just be new advances in climate change litigation. We can discuss about that at the end. We have the rights-based litigation in terms of Pil and Ozovsky. We have torts litigation. We have investors and financial control litigation, and so on. The more recent cases that we will discuss today with our hosts can be considered a mix of those different trends and break the new indeed considerably. The German Constitutional Court decision ruled last March that Felix will discuss and present, defending rights and freedoms of the youth and future generations, and tending to consider unconstitutional the climate change German law. It's clearly a rights-based case, but also based in international law, the Paris Agreement targets, and maybe more importantly and new, based on specific science data. The fact that future generations, if we continue like that, will never be able to live with the same freedom and the same opportunities in terms of quality of life, dignity, well-being as the present generations. And this is what we can call a long-term strategic case. And if we take a mid-term strategic case, we have the very recent case in the Netherlands against Shell that was ruled last May, 2 weeks ago, by the Court of District of The Hague, tending to modify the activities based in the duty of care of the company and to enlarge the responsibilities, both on scopes based on the emissions of CO2, scope 1, 2, and 3, which is completely new. The plaintiffs in this case were not seeking financial compensation, but they were asking the company, Shell, to adjust its business model in order to keep global temperature rise below 1.5 degrees Celsius. Once again, science data was at the center of this decision too. So as we can see, new strategic climate change litigation is evolutive, is innovative, and moreover, is dashy and bold. So thank you very much. And now I pass the floor to our first host, Michael Gerard. Michael, you have the floor.
Thank you very much, Marta. It's a pleasure to join you from New York. Let me start by sharing my screen. Here we go. So our center at Columbia Law School maintains a database that tries to include all of the climate change cases around the world. These are the links to the database and how to receive monthly updates. I'll send this around in the chat. In all, we have counted 1,587 cases. This is as of May 2020. There are a number of cases since then. Of these 1,587 cases, 76% are from the United States. The United States has far and away the most cases on climate change in the world. Australia is a distant second. The United Kingdom is a distant third. But in all, there are lawsuits that we've counted in 40 countries and also 9 international tribunals. The lawsuits really took off, became numerous around 2007 and have continued to increase. This is just a partial 2020. The end of the year was much larger. So in blue, we have the United States cases, and in red, we have the cases in the rest of the world. Since 3/4 of all the cases in the world are from the United States, I'm going to begin by focusing on the US cases. So the largest number of climate change cases in the US were brought under the National Environmental Policy Act, which is the US law on environmental impact assessment. Some states also have similar laws led by California. And so we see 139 cases under these state equivalence laws on environmental impact statements. So by far the largest number of cases in the US are on environmental impact assessment, typically challenging the approval of particular projects or particular regulations for not giving enough attention to climate change impacts. We also have a great many cases under the Clean Air Act, the principal U.S. statute on the issue, and then cases brought under the Endangered Species Act and many other theories. So one of the most important U.S. cases was American Electric Power versus Connecticut. This was a lawsuit brought by the state of Connecticut and other states against several electric power companies, asking the court to impose an injunction on several power companies, requiring them to reduce the use of coal to generate electricity. That case was ultimately dismissed by the United States Supreme Court on the grounds that the Clean Air Act of 1970 had given the Environmental Protection Agency, the EPA, the authority to regulate air pollution. The Supreme Court has said that applies to greenhouse gases. And this lawsuit was brought under the federal common law of nuisance, a US doctrine where the federal courts can fill in the gaps in certain important issues, especially for issues that are national and that cross borders. So the Supreme Court said that there was no longer a gap to be filled, that the EPA has the authority to regulate greenhouse gases, and therefore the federal courts should not set their own rules on allowable levels of greenhouse gases. There was another important case at that time brought by a village in Alaska, the village of Kivalina, that's on a very narrow peninsula, and they were endangered by the melting of the sea ice. So they sought money damages from ExxonMobil and several other energy companies, saying that those companies were responsible for climate change. The court said that the ruling in the American Electric Power case I just discussed, which was about injunctions, also applied to lawsuits for money damages. And so this lawsuit was dismissed. So these were under a federal law brought in federal court. In 2017, we saw the beginning of a second wave of climate change litigation seeking money damages from fossil fuel companies. There are now about 20 of these lawsuits. They were mostly brought by cities and counties. Some of them were brought by states. All of them name Exxon as a defendant. Others also name other fossil fuel companies and other defendants. And they assert a variety of claims, but mostly these common law nuisance and trespass claims. These are the same cases The big issue has been whether these cases belong in federal court or state court. The defendants, the oil companies, want them to be in federal court because if they stay in federal court, it may be that the courts are more likely to dismiss them under the ruling in the American Electric Power case that I talked about. The plaintiffs, these cities and counties and states, want them to be in state court under state law. So ever since these cases were brought in 2017, there has been litigation about whether the cases belong in federal court or state court. Just last month, the U.S. Supreme Court issued a ruling on a narrow procedural issue in one of these cases on whether it should belong in federal or state court. So these disputes are going to continue. However, there's another one of these cases which was brought by several cities in California against Chevron and several of the other fossil fuel companies. This case was dismissed by the U.S. Court of Appeals for the Ninth Circuit, and the fossil fuel companies have asked the United States Supreme Court to review it. The Supreme Court may decide as soon as tomorrow whether to review the case, and if it does, the Supreme Court may look beyond this narrow jurisdictional issue and the plaintiffs want to stay away from the Supreme Court. In general, in the United States, environmental groups want to stay away from the current Supreme Court because it has a current 6-3 conservative majority, including 3 justices appointed by former President Trump. But we'll know soon whether the Supreme Court takes this case. If any of these cases do proceed to the merits, most of them rely on a series of studies mostly done by an analyst named Richard Heady, who has looked at the history of fossil fuel production and come up with these tables that look at the amount of oil and coal and gas extracted by these companies and their predecessors, and how much the combustion of those added to the load of greenhouse gases in the atmosphere, and saying that these companies should be liable. Only the private companies, the companies owned by states like Saudi Aramco, usually have sovereign immunity. Another theory that some of the more recent US cases are asserting concerns advertising and marketing. The oil and gas companies spend a great deal of money on advertising, and the cases allege that these companies were deceitful, or at least some of them were deceitful. Some of them lied about the impact of climate change, and that's an additional basis for some of these lawsuits. One effort to go against the oil companies that failed was brought by the Attorney General of the state of New York, using the New York State laws on securities disclosure. So New York sued Exxon, saying that Exxon was guilty of fraud in the way that it talked to investors and the public about climate change. There was a trial. There have been very few actual trials in any of these cases, but there was a trial here before a judge, and the judge said that New York had not proven its case, and they dismissed the lawsuit. So far in the United States, none of these lawsuits against fossil fuel companies based on climate change have succeeded in holding the fossil fuel companies liable or responsible for climate change. There have been quite a few successful lawsuits about particular projects, about power plants or pipelines to carry natural gas, or coal mines. But those are usually cases brought on environmental statutes, such as the National Environmental Policy Act or the Clean Air Act. None of these broader cases asserting common law rights or constitutional rights in the United States have succeeded. However, as Marta just mentioned, there was this very important decision last week in the Netherlands in which the the District Court of The Hague ruled that Royal Dutch Shell must reduce its greenhouse gas emissions 45% by the year 2030, and that this applies not only to the direct emissions from the oil company's operations, such as its refineries, but also the emissions from by its customers and the people who drive the vehicles, the Scope 3 emissions. This is a very unusual, very important ruling. It applies not only to Royal Dutch Shell's operations in the Netherlands, but also to their operations around the world. There is a similar lawsuit now pending in France against Total. I think that there will be other lawsuits brought in other countries around the world inspired by this decision from the Dutch District Court. Now, this is just a district court opinion, a lower court decision. Shell has already announced it will appeal to the higher courts. However, the court that issued this ruling is the same district court that issued the very important decision in the Urgenda case, which Marta also mentioned. And as we all know, in 2019, the Supreme Court of the Netherlands ruled in favor of the plaintiffs and ordered the government of the Netherlands to reduce its greenhouse gas emissions more than the Netherlands had promised in the Paris Climate Agreement. So at the time, I said that this was the strongest decision by any court in the world on climate change. It was the only decision that where a court had directed a national government to reduce the country's greenhouse gas emissions and based on constitutional or human rights grounds. We now, of course, have the very important decision from Germany, and Felix will talk about that. We also last month had an important decision from Australia, where a court ruled that the government has an obligation, a duty of care to young people to protect them against climate change. This case involved the permit that the Minister of the Environment of Australia was considering for a coal-fired power plant. The court did not direct the minister not to issue the permit because she had not yet decided, but it said that in issuing her decision on the permit for the coal mine, they needed to consider these climate change issues. If the minister grants the permit, I'm sure she will be back in court on these theories. There are a number of other decisions for the plaintiffs on human rights and constitutional grounds in Pakistan. A court found that the government of Pakistan was not carrying out its duty to adapt to climate change, to prepare for climate change. And so the court created a commission to come up with a plan to prepare for climate change. The court appointed the members of the commission, and it has continued its work. In Colombia, the Supreme Court ordered the government of that country to protect the Amazon forest for future generations based on, again, human rights issues. In Nepal, the Supreme Court of Nepal said that the national government has an obligation to do more on climate change. It directed the parliament to adopt a climate change law, And the parliament did that. The parliament of Nepal and Kathmandu obeyed that order and adopted a climate change law. In the Philippines, the Human Rights Commission has been holding hearings on the responsibility of the fossil fuel companies for climate change. However, this commission has no power. It only can issue advisory opinions. In Nigeria, a judge ruled that gas flaring violates the constitutional rights of the people who live nearby. However, this was in 2005, and gas flaring continues. So that shows some of the limitations of some of these cases. In some countries, a ruling on human rights does not necessarily lead to action. It is not necessarily enforceable. So let me turn back to the United States, since again, that's where most of the cases around the world are brought. We have a new kind of case being brought, which is for failure to adapt. These are not cases based on greenhouse gas emissions. These are cases saying that there is a danger of climate change and companies need to prepare for it. So we have two lawsuits pending in US federal courts, one against ExxonMobil, one against Shell, not because of their fossil fuel production, but because they have oil tanks along along bodies of water. And the plaintiffs say that these oil tanks could be harmed by coastal storms worsened by climate change, and the oil tanks could burst and cause an oil spill. And these lawsuits are saying these companies need to do more to prepare for that. There are lawsuits pending in Texas because a major flood in Texas caused an explosion at a chemical plant. And the lawsuits say the chemical company needed to prepare for this kind of flood. There are lawsuits in California because there have been many wildfires, which may have been caused by sparks from the electric utility. So there are lawsuits against the electric utility company and some of its officers for not preparing. In the United States, the most famous case on climate change in recent years was the Giuliana case. And I don't have time to talk about it in detail, but it was an attempt to establish a constitutional right to a clean environment. It received a lot of attention, but ultimately, and I'll flip through these, the court majority said, no, we agree that climate change is a terrible problem, but it is not our job. It is not the job of the courts to address the problem. It's really the responsibility of Congress and the president to act on it. So the court said, although we agree that climate change is a real threat and it needs to be addressed, we judges will not address it. The U.S. courts have been important in interpreting statutes. In 2007, of course, the Supreme Court ruled that the Clean Air Act applies to greenhouse gases, and this decision became the basis for President Obama's actions on climate change. Most of them were upheld, but in 2016, the Supreme Court ruled that President Obama had gone too far in one of his regulations, the Clean Power Plan. During the Trump administration, there were many lawsuits brought by environmental groups saying that the Trump administration had gone too far in revoking and taking away the regulations that on climate change and other environmental issues that had been adopted under the Obama administration. And many of those actions were thrown out in court. Many of the actions by the Trump administration were thrown out in court, mostly on procedural bases. So the courts have continued to be very important. And now with the Biden administration going in the other direction, We know that the fossil fuel industry and some states like Texas that oppose climate regulation will be challenging everything that the Biden administration does. So thank you all, and that's my presentation.
Thank you very much, Michael. Maybe we can pass the floor to Felix and then start some debate between us and with the public. I think there are some questions already there and probably many more will arrive. So Felix, have the floor.
Good afternoon, everybody, or good morning, depending on where you are. I'm going to talk about climate or climate litigation, human rights and freedom, using mainly the example of Germany. One could start here by discussing the term climate litigation. I always wondered during Michael's beautiful talk what climate litigation actually is. For instance, we have hundreds of lawsuits against roads, against power plants, against regional planning measures, etc. in Germany, and they all deal somehow with climate change, with climate protection. But I'm not sure if anybody counts these cases, but I think I'll drop this here. I focus on my topic. I just wanted to mention this here. I'm going to talk about the German case, as I mentioned. The fundaments go back to my research carried out around about 20 years ago in my postdoctoral thesis called Theorie der Nachhaltigkeit. There's also an English version, a shorter version, published with Springer Nature in 2019 called Sustainability, Transformation, Governance, Ethics, Law. And an important part of the book deals with sustainability, freedom, and human rights. This research was discovered by a very small German environmental NGO called SFV, Solarenergieförderverein Deutschland, which means Solar Energy Support Union. They were always fascinated by the idea of obliging the German parliamentarian majority to a much more ambitious climate policy, believing that it's complete fake, all this talk about the German status as a climate role model, because they know the per capita emissions of Germans are among the highest in the world. And they wanted to challenge this before the court somehow. So they discovered my research. They asked me for some legal opinions over a couple of years. And then in 2018, we formed a lawsuit alliance, and it was really hard because no one wanted to join us, literally no one. All the environmental NGOs refused to join. So we just did it with a small number of individual plaintiffs, some people that are quite well known in Germany, like actors, former members of parliament, etc. The first one was Josef Goeppel. This is why the case is called Goeppel et al. And also Friends of the Earth, at least Friends of the Earth Germany supported us, but all the other environmental NGOs like Greenpeace, etc., refused to be part of it, knowing that in the past all lawsuits in favor of more environmental protection at the Federal Constitutional Court of Germany failed. And then in August of 2019, it happened what more or less no one accepted. The German Federal Constitutional Court accepted the case for decision. And after that, it was like a complete change of mood. Everybody wanted to join. And then we've seen 3 more constitutional complaints brought to the court in January 2021. For instance, by Fridays for Future activists, farmers, supported by further NGOs such as Greenpeace, etc. In this spring, we got the verdict of the Constitutional Court, which is quite historical for various reasons. First of all, it was the first successful lawsuit in Germany before the Constitutional Court aiming at more environmental protection. We have to stress this because there have been dozens of successful claims aiming at less environmental protection. I mean litigations by lawsuits by companies or whatever, but we're talking about more environmental protection. The court delivered an extensively different interpretation of the liberal democratic principles of the Constitution in this ruling. And I never believed that they adopt so much of our arguments, so much of our ideas, but they did it in a way, and this feels still quite very astonishing for me. Maybe it's the most far-reaching ruling by a Supreme Court on climate in the world by now. At least it's definitely more far-reaching than the Giuliana case in Netherlands, which more or less only stated that the Dutch government is not entitled to water down their targets that they already accepted once. The core statement of the German Constitutional Court is that the legislator has to balance or has to find a fair balance between the intertemporal spheres of freedom. This is the most important point. They also ruled that climate targets must be regulated in the long term by the parliament, and just generally all the important decisions on climate change have to be done by the parliament, not by administrative authorities or by the government. There are further important innovations in this ruling that form the fundament for this core statement. For instance, the court accepted an intertemporal and global concept of human rights, an intertemporal and cross-border concept of freedom. Freedom is not only the freedom of people living here and now, but also living somewhere else or belonging to future generations. They also accepted that freedom, constitutional freedom, includes the precautionary principle, which means that human rights lawsuits do not necessarily have to be based on things like encroachments that definitely take place like here and now. There can be uncertainties regarding facts, etc. This is no general problem. Furthermore, the German Federal Constitutional Court accepted that there is a constitutional right to the fundamental preconditions of freedom: life, health, and subsistence. And this is also the case when a given situation affects more or less everyone. In the past, German courts had a tendency to hold human rights only applicable in cases where very few people were affected. And in cases where literally everyone was affected, they say it's the task of the parliamentary majority to solve this problem, not a task for the courts. And they changed this and said, okay, everyone is affected by climate change, but never mind. It is possible to go to court on this basis. I think the most important theoretical aspect of the ruling is maybe the following. The court accepted our model of what I like to call double threat to freedom. Climate change, on the one hand, poses serious risks for the vital basis of our freedom. And on the other hand, climate policy itself, given that it takes place too hastily, can also become an infringement of our freedom. So the task of the parliament is to balance spheres of freedom in a fair way. What is also quite important is that the court accepted that the Paris target, the target laid down in Article 2, Section 1, or Paragraph 1 of the Paris Agreement, is to be read as a 1.5 degrees Celsius target, not 2 degrees or well below 2 degrees. They say we have to go for 1.5 degrees, or we have to stay within the limit of 1.5 degrees Celsius. And they also say this is legally binding. This is not just a non-binding idea like the SDGs or something like that, but it's legally binding. Nevertheless, there are also some disappointing aspects in the ruling, in my opinion. Let me just make 3 points. The first one is the double threat to freedom is accepted by the court, but in a way it is misconstructed, in my opinion, or to put it in other words, it is constructed in a very classic liberal way. The court talks like climate policy is the more severe or the primary threat to freedom. I think this is clearly wrong, given what might happen due to climate change and its consequences. This takes us to the next point, which forms the legal basis for the idea of the court that climate policy is more dangerous than climate change. The court, in a way, downplays the relevance of the right to the elementary preconditions of freedom. For instance, the court mentions that this side of the double threat to freedom may also be solved by adaptation measures. And I think this is clearly wrong, given the consequences of climate change, such as wars on resources, or breakdown of the global food supply, water supply, whatever. I don't see how this could be solved by means of adaptation or huge migration flows or whatever. What is also kind of disappointing is that the court still sticks to its very old, or in other words, classic liberal idea that human rights are mainly about respecting freedom by the state, but not protecting freedom by the state against the fellow citizens. The court gave the impression protecting citizens against climate change is only about the protective side of freedom, the protective side of human rights. I think this is flawed for at least 2 or 3 reasons. The first one is what happens in terms of climate change can easily be seen as encroachment of the respect side of freedom as well, given that the court entitles people to drive a car, entitles companies to run a fossil fuel power plant, entitles companies to participate in emissions trading schemes, etc. Why can't we see these entitlements as encroachment of human rights? Why do we have to put it in a way like it is only about the state protecting us against fellow citizens? And even if this was correct, the question is whether the concept of separation of powers the court uses is convincing. The German concept of separation of powers, and also the concept of various other Supreme Courts in other countries, is, as far as I see it, that lawsuits based on the protective side of freedom are more dangerous for separation of powers, because they sound like someone wants to force the court to tell the parliament what exactly they have to do. But this is not what protective claims, what protective lawsuits are about. They, just as lawsuits based on the respect side of freedom, just want a court to set a framework, to say there's a framework that mustn't be violated. So I cannot see the overall difference. And in a way, the German Federal Constitutional Court understood that, because they didn't discuss the idea what exactly the German parliamentary majority has to do. They just said, okay, there's a deadline until the end of 2022, and the German parliament has to rethink climate policy on the basis of the idea of a fair balance in terms of greenhouse gas budgets for all generations. And this is clearly what we talked about. But this idea could also have been based directly on the right to life, health, and subsistence. There was no necessity to use a rather blurred basis for this side of the double threat to freedom, which was taken from the overall state objective to protect the environment, which is usually seen as completely vague and not very contured. The third weakness of the ruling, in my opinion, is the following. It has something to do with the greenhouse gas budget and the Paris target, a target from Article 2, paragraph 1 of the Paris Agreement. The court clearly accepted, as I mentioned earlier, that the 1.5 degrees Celsius limit is legally binding. And it's also lovely that they said it is 1.5 degrees Celsius, not 2 degrees. And they also mentioned that it's probably unlawful, or at least maybe unlawful, to rely on overshoot or on geoengineering, like for instance, solar radiation management, while trying to meet this or staying within the limit of this target. But apart from that, they completely adopted the way the IPCC calculates its budgets, although they're both empirical and legal arguments that the IPCC budget may be too large. Why is that? Well, first of all, we have to point out that what the IPCC does when calculating a budget is something like a lowest common denominator. Yeah, like they're a consensus panel. They have to formulate ideas that are acceptable for everyone in scientific community. Given that, they look at empirical uncertainties regarding climate change in a sometimes quite optimistic manner. This is the case, for instance, with regard to climate sensitivity. Furthermore, they make some assumptions that could be challenged from the legal point of view. And we challenged that in this case. And what is really amazing, that the court didn't even discuss it. They didn't even mention it. For instance, the IPCC budget is calculated on the basis of a probability of only 67% of staying within the 1.5 degrees Celsius line. But given the 1.5 degrees Celsius target is legally binding, how can we say it's fine to accept just 67%? Why not 99% or 95%? Given that, the budget would have to be a lot smaller. Another point is, further points, I just mentioned one more. Another point is the base here. Article 2, paragraph 1 of the Paris Agreement says that the target has to be calculated compared to pre-industrial levels. But what is pre-industrial? The IPCC usually uses a base year from the second half of the 19th century. But as we all learned at school, industrialization didn't start in the second half of the 19th century. It started as early as 1750 in Great Britain, or let's say 1820 in Germany. Given that, the budget would have to be still smaller. And even the IPCC budget, just if we take it as it is, and if we take a linear reduction pathway and distribute the remaining budget on a global scale on a per capita basis, would take us to a zero emission line only in 2035. Given my objections against the budget, it probably would have to be earlier. I know this is very, very challenging, very hard to imagine, but what is kind of disappointing that the German Federal Constitutional Court didn't even discuss it. Let's make some final remarks on the political consequences on my last slide now. What happened after the ruling is the following. The German parliamentary majority immediately passed a new overall climate law. I mean, there are various acts of parliament in the EU and Germany that deal with climate law somehow, but there's an act of parliament in Germany directly called climate law, Klimaschutzgesetz, and it contains the overall targets of German climate policy. And what the parliamentary majority did is that they raised the ambition of the 2030 targets. They raised it from minus 55% greenhouse gas emissions to 65%, measured against 1990 as a base year. This is quite good, but probably still not in accordance with the court's rulings, because given that the present generations would still consume more or less most of the budget, or even all of the budget remaining. What is also to be pointed out here is the following. It's clearly not enough that the German government and German parliament reacts on the court's ruling, because the Federal Constitutional Court clearly stressed that climate policy is an international matter, and the German government, the German parliamentary majority, have to massively bring forward climate protection also in the transnational sphere. And this is really important, given that most of the emissions are distributed or governed on EU level now, and it will become even more that are governed on EU level after the next EU climate policy reform, which will start in summer. The EU Commission will present its proposals for improved EU policy instruments in a couple of weeks. And they already presented new targets for 2035, still not in accordance with Article 2 of the Paris Agreement, but at least better than the targets we had before. And what we can learn from the Constitutional Court's ruling is that at least the German government, the German parliamentary majority, will have to force the EU Commission to be more ambitious. And I'm not sure if they really do it. We are clearly prepared to bring one more constitutional complaint to the court next year, because we expect that climate policy is getting better, but still not good enough, measured against the 1.5 degrees Celsius limit. Nevertheless, one could already see during the last weeks that the court's ruling is getting adopted by administrative authorities, by lower court levels, when dealing with lawsuits filed against roads, etc. So we don't really know yet how big the influence of the court's ruling will be, but given the high recognition of the German Federal Constitutional Court, I'm pretty sure there will be a lot of consequences, although the court's ruling, in my humble opinion, is not completely satisfactory. Thank you for listening.
Well, thank you very much. Thank you so much to both of you. We have a lot of questions from many people here. So maybe I will make some groups of questions. First questions to Michael, Gerard. One of them is why you think there are so many cases in the United States? And two, what do you think it will take for those cases to succeed?
Well, the United States has a culture of litigation. We have a lot of lawyers who bring a lot of lawsuits, and there are many environmental groups that bring lawsuits. Many states now are bringing lawsuits. One difference between the United States and many other countries is that in the US, each party usually pays its own attorney's fees regardless of who wins the case, whereas in many other countries, the loser has to pay. And so in the US, there is very little risk of bringing a lawsuit that is ultimately unsuccessful. But I think part of it is the culture of litigation. So many of the lawsuits do succeed, the lawsuits that are challenging particular individual projects or individual regulations. It's the difficulty is the much broader kind of strategic litigation, such as Felix described as succeeding in Germany. The current US Supreme Court is very conservative and does not seem to be very favorable toward that kind of case. We'll know more possibly after the next round, but so far the US Supreme Court is not a good place for this kind of litigation.
Okay, thank you. And a question for Felix now. How do you evaluate human rights-based climate litigation? Well, I think, Michael, you can answer to you want to. And to both of you, how can it contribute or can it contribute significantly to the fight against climate change or not?
Well, if I shall start, given the overall model that the role of the Constitutional Court is only to set a framework, to establish a framework, and within this framework, it's up to the parliamentarian majority what they do or not. The idea of a constitutional complaint of that kind I talked about is just to stress this framework and to tell the majority you act outside this framework. And this is what we got from the court. We got the obligation of the parliamentarian majority to stay within this framework. And the practical result was, as I mentioned, that we got stronger, more ambitious climate targets in Germany now. Still not ambitious enough, in my opinion, because the court should have looked on the budget more closely, in more detail, but nevertheless, it's a big success.
Well, this is linked to another question for you too, which is if you want to answer, what were the arguments of the court to consider the 1.5 degrees Celsius legally binding, as you said?
Well, if you mean the German case, yes. I could answer that. The agreement in general is considered as binding, and Article 3 and Article 4 of the Paris Agreement mention that the basis of more or less everything that takes place under the agreement is the overall target, which can be found in Article 2, Paragraph 1. So this is the basis for the court saying, okay, it's legally binding. And why 1.5 degrees Celsius, not 2? Article 2, Paragraph 1 says well below 2 degrees Celsius, and states have to pursue efforts towards 1.5 degrees Celsius. But what does well below mean? Something like, I don't know, 1.7 degrees Celsius maybe. And if there's an additional obligation to pursue efforts towards 1.5, this means we have to try to stay within this line. Otherwise, it makes no sense to say we have to pursue efforts. And this is why the court says it is 1.5 degrees.
Okay. And legally binding.
Pardon?
And legally binding then.
Yeah, well, and legally binding due to Article 3 and Article 4, Paragraph 1 of the Paris Agreement, which mention Article 2 as the basis for all detailed regulations of the agreement.
Okay, thank you. And I have a question to Michael now. It's about Africa, because you said that Nigeria case shows the limits of climate litigation. And someone is asking if you think there is climate litigation opportunities in Africa.
Yes, there are a few climate change cases pending or that have been decided in Africa, in addition to the case I mentioned in Nigeria. In 2019, a court in Kenya struck down the approval of a power plant in Kenya because of its climate change impacts and sent the approval back to the administrative agency. In 2020, a court in South Africa ruled that aquifer protection of the groundwater was important, and that it was endangered in part by climate change, and that the government needed to do more on that. There are two pending cases that I'm aware of. There's a case in Uganda that's been pending for some time based on public trust theories. And in the East Africa Court of Justice, there's a lawsuit against Tanzania and Uganda concerning an oil pipeline. That was brought last year and is still pending. So we don't have a large number of cases in Africa, but we do have several. And they're all in the climate change database that I sent around the link for that.
Okay, so there are definitely litigation opportunities in Africa.
Yes.
And I have a question to Felix now. Could you please expand on the model of double threat to freedom that you said in the lawsuit? What you call the model of double threat.
As I mentioned earlier, human rights are about freedom, and given there's a guarantee for freedom, there's also a guarantee for the elementary preconditions of freedom, such as life, health, and subsistence, which is logically implied, because otherwise freedom wouldn't be guaranteed, because freedom without having something to eat, to drink, etc., takes you nowhere. Even if there is no constitutional guarantee, no explicit constitutional guarantee for these rights, there must therefore be accepted. But for instance, in German constitutional law, the right to life and health is explicitly mentioned in the constitution. The right to subsistence is not mentioned, but the court adopted it in the way I told you now. Given that, climate policy and also policy in general is always about balancing different spheres of freedom. Given climate and with regard to climate policy, this poses what I call the double threat to freedom, that on the one hand, we can lose our freedom by losing the vital basis in climate wars, etc. On the other hand, we can lose our freedom by means of some kind of eco-dictatorship. We just postpone climate action. Then one day we do it very hasty, cut down our emissions from 100 to 0 in, 2 weeks. This will be possible only with the means of a dictatorship. To avoid this is what I call the idea of avoiding the double threat to freedom. And the court adopted it in a way, they call it a bit different. They say it is all about securing freedom on an intertemporal level. We have to balance freedom between generations.
Yes. Okay. Thank you very much. That was really very clear. I have another question for Michael. It's about the Giuliana case that didn't succeed for the moment. And the question is if you have other prospects in the United States under the US Constitution about based in those general environmental health rights considerations and general welfare.
Well, until the Giuliana case, no U.S. court had said that there is a constitutional right to a clean environment. There's nothing in the text of the U.S. Constitution that says that. The district court in the Giuliana case said there was. The Court of Appeals, the Ninth Circuit, had some sympathy for that, but ultimately did not rule for the plaintiffs. Once again, I do not think that the U.S. Supreme Court is likely to be favorable to that kind of theory. There are several states that in their own constitutions have a right to a clean environment. And in fact, this November, there is going to be a public referendum on whether to amend the Constitution of the state of New York to add a constitutional right to a clean environment to the New York State Constitution. The idea of the general welfare and the importance of keeping the air pure and the water pure and that sort of thing is well established as a legal basis for the government to act And so the federal government and the state governments clearly do have the authority to act to keep the air clean and the water clean. However, the courts have not said that it is a basis for citizens to sue the government to act further unless there is a specific statute or regulation involved. Almost always the courts will ask the question, well, what do the statutes and regulations say? And they will enforce those, but they will not go beyond those.
Okay, and Felix, this is a question for you. Could you please remind the name of the association with which you work together?
I didn't get it. Yes, yes.
This is the question as it's asked. Can you please recall?
Let me have a look. Is it written down here in the question?
Yes, in the QR. What's the name of the association?
The association.
Yes,
association.
yes,
oh,
the association. The NGO or
yeah,
the
association. Yes, the German name is Solar Energie Förderverein, SFV. The English translation would be Solar Energy Support Association or Solar Energy Support Union or whatever. It is an environmental NGO that focuses on the role of the small owners of solar panels, not the big ones, but the small ones. And they have former CEO, and very old one, I think he's 87 now, Wolf von Fabeck. I can write down his name here in the commentary section, Wolf von Fabeck. And he's absolutely radical in terms of climate protection. It was mainly his idea 10 years ago, 11 years ago in 2010, that he more or less forced his fellow members of this NGO to prepare a lawsuit for the German Federal Constitutional Court in the long run. This is quite funny because I read in international newspapers sometimes that a German lawsuit is a youth lawsuit. Yeah, this is really absolutely wrong. Yeah, because it was all because of the furor of Wolf von Fabeck. All the young protesters only joined us when it was already clear that the Constitutional Court liked our lawsuit. Yeah, and Luisa Neubauer is one of these young protesters, for instance.
Okay, thank you. And this is, I think, to both of you, so any one of you can answer how the climate litigation has been considered in the small islands, the developing states. What do you think about that?
Well, there was an action taken several years ago by the Federated States of Micronesia challenging the construction of a power plant in the Czech Republic for not doing enough of an environmental impact assessment. That power plant ultimately was never built. Beyond that, there have not been many lawsuits by the small island states. I've been working with the Republic of the Marshall Islands closely for over a decade, and there's been an effort to get in front of the International Court of Justice in The Hague with a decision on the obligations of major emitting countries to reduce their greenhouse gas emissions, because without that, the small island states will be underwater. The Marshall Islands and Palau have worked together on that, but it requires a majority vote of the United Nations General Assembly, and that has not succeeded. There are still ongoing efforts to get in front of the International Court of Justice. But beyond that, there have not been many lawsuits brought by the small island states, although there has been a great deal of consideration on the exactly right legal theory has not been found yet.
Okay. And here's a question for Felix. Could the ruling in Germany have a retroactive effect?
What kind of effect? Retroactive?
Retroactive.
Retroactive.
I'm not sure what that means.
Would it apply to the past? Does it apply to things in the past and not just the future?
Yeah, but
it really depends on what exactly retroactive should mean here. I mean, this is I think this is a Latinism, yeah, but what does retroactive mean?
I don't know. Maybe maybe means that if it could be a precedent for another considerations of anti-constitutional laws or regulations in the same basis.
Yeah, well, first of all, we have to stress here, we have statutory law, not case law in Germany. So everything the Federal Constitutional Court does is about interpreting the German basic law, the Constitution of Germany. So we wouldn't call it a precedent. This is the first part of my answer. But nevertheless, given the high recognition of the German Federal Constitutional Court that I mentioned earlier, I'm pretty sure that the ruling will be highly influential all over Europe and maybe even all over the world. Yeah, I mean, there is a close interaction of Supreme Courts all over the world. For instance, in a couple of weeks, there will be a meeting of the German Constitutional Court with the judges from the Supreme Court of Colombia. Yeah, and meetings like that take place all over the time, all the time. But this is, I think, this is still not what I would call retroactive, because retroactive is about the past. Yeah,
no problem.
I don't know.
Now I have a question to both of you. Could you, that I joined this question because I wanted to ask it myself. So someone is asking it too. Could you further reflect on the effects of the Paris Agreement on climate litigation? Do you think that this is going to help other type of cases, new type of cases that couldn't be developed if there was not Paris Agreement? Or what is the place of the Paris Agreement in all that litigation? In other words, to be simple.
I think that the goals established by the Paris Agreement establish a standard that can often be used in cases to say that a country or company needs to try to meet those standards. There was important litigation in the UK over the construction of a third runway at Heathrow. And there was an initial decision saying that the government needed to examine explicitly the consistency of building that airport runway with the UK's pledges to Paris. That was ultimately overturned by the higher court. But I think we'll see more of that. I think we'll see more demands in litigation, and also politically that decisions by governments be consistent with the Paris Agreement. We are also seeing many pledges by private companies to act in a way that is consistent with the Paris Agreement. And if the companies make that kind of promise to their consumers and to their investors, and then fail to meet those promises, that also could be a basis for litigation. Though the companies themselves are not directly bound by Paris, but if they bind themselves to Paris by these public announcements, that could be a basis for litigation if they fail to meet those promises that they made.
If I may add on that, what we brought forward in our lawsuit is the following. We presented the idea that the Paris target is simply more or less identical with the constitutional limit in terms of climate change, given that democratic policy is about balancing different spheres of freedom, given that balancing has a framework which consists of balancing rules that can be derived from the rights to freedom and elementary preconditions of freedom and further principles. One balancing rule, for instance, is that the parliamentary majority is not entitled to put the vital basis of further balancing at risk. And this is what might happen if we ignore the 1.5 degrees Celsius limit, because irreversible processes will start then, etc. And this is why we propose that that the court chooses an interpretation of the liberal democratic constitution of Germany that is in line with the international agreement called Paris Agreement. So in the end, our idea is not that citizens of Germany can directly base lawsuits on the Paris Agreement. Paris Agreement doesn't mention any individual rights or whatever, but the Paris Agreement mentions that the agreement was established with the idea of human rights as a background, etc. So it makes sense that courts on national level or EU level or wherever read this agreement carefully, and this is what more or less happened in several cases. For instance, also in the Shell case, but it was really amazing. I mean, we got this ruling like 2 weeks ago, and the district court of The Hague made something very strange. I think we didn't mention this yet in this panel. On the one hand, they say without any argument, the Paris Agreement is non-binding, neither to states nor to companies. But on the other hand, they say there's an overall obligation to due diligence which can be interpreted in the light of the Paris Agreement, which takes us to some binding obligations.
Yes, I agree.
I put a commentary on this in the commentaries section, which I published.
Yes, it's very. I agree with you. The shared decision is indeed complex and ambiguous, but this duty of care and due diligence is interesting too. I have a question for you, Felix, if you will have still 2 minutes, I think. You said that now with this decision, the German Constitutional Court, the German government has to force the European Union to be more ambitious and in order to align one to the other, of course, because if one state is doing more, the European Union has to do more, and then the other states should do more. Is that your reasonment, or?
It's a kind of different. Even today, it is pretty clear that only about 40 or 45% of the emissions of Germans can be governed by the German government and German parliamentarian majority, given that there's a lot of climate law on EU level. And it will probably be more after the next EU climate policy reform, which will start this summer, as I mentioned earlier, because the EU Commission will probably propose to include more or less all fossil fuels in the EU emissions trading scheme. For instance, given that there is no possibility anymore for German government, German parliamentary majority to cut down German emissions. Yeah, it has to be done by means of getting an ambitious EU emissions trading scheme, and this is why we, for instance, put put it to the we mentioned it in our lawsuit at the German Federal Constitutional Court that we wanted the court to clearly rule Germany has to do more on EU level. This is not what they did. They said, okay, there's an overall obligation of German government to act on international level. Otherwise, climate protection will not work.
Yes.
And so we're not quite sure what is going to happen now, but at least in our reading, there is this kind of obligation. Germany has to force the EU to come to an optimal kind of climate policy reform in summer.
Well, I think it's an amazing decision. And thank you so much to both of you for those great presentations. And I think that the theory of the drop in the ocean with this German constitutional decision is at the center of it. So maybe you have some words if you want to conclude. Do you have a sentence that you want to send to the audience? And
so let me just say the question arose of what kind of cases do we include in our database? We include cases that explicitly talk about climate change. There are many other cases that are relevant to climate change, like road construction or pipelines or power plants, but do not explicitly talk about climate change. And we don't include those. We work closely with the Grantham Institute at the London School of Economics, and together we try to find and post every lawsuit in the world that concerns climate change, but we may miss some. And so anyone who is aware of any relevant lawsuits that are not included in our database, please send them to me. I'm fairly confident we include the relevant cases in the US and Germany, I'm sorry, the US and Europe. But in other parts of the world, it's more difficult to find them. So please do send me any cases that should be in our database, but that are not yet there.
of course. Of course, we will. Thank you very much. Felix, do you have something to say, a message you want to send?
I think I already talked quite a lot. Thanks a lot for organizing the webinar. It was very, very inspiring. Thank you.
Well, thanks to you. And I think that as we have seen, this litigation, climate litigation can have a lot of impacts, direct and indirect, and probably financial, but maybe we will talk in another webinar about that. Thank you so much for your presence, for the time you gave to us, precious time, and for all your presentations, and that was really thrilling and inspiring. So thank you to all.
Thank you.
Thank you.
Bye.